also provides that courts have no jurisdiction over acts of state. From the foregoing provisions, we may know that terms of the Act of State in China refers to acts by the Ministry of Foreign Affairs and the authorization of the Constitution and the laws. However, the accurate meaning of acts of state is to be clarified. The first issue is who determines foreign sovereign state. According to one voice doctrine, when the state involved in a case constitutes a foreign sovereign state as defined in subparagraph 1 of Article 2 of the law, acts of state will be involved. The foreign state immunity law provides an immunity of a foreign state. So, determining which entities constitute foreign state is the primary issue in applying the law. Determining whether the defendant constitutes a foreign sovereign state and who represents the foreign sovereign state involves sensitive diplomatic matters such as national recognition and government recognition. According to one voice doctrine, it is a political decision, and the act of state that's not subject to judicial review. Paragraph 1 of Article 2 of the law defines a foreign state as a foreign sovereign state. So, the Ministry of Foreign Affairs has a conclusive law in determining the foreign sovereign state. Second, while the service of the diplomatic note specified in Article 17 of the law is effective. As we know, service is a prerequisite for the case to move forward. If the defendants are not served, the proceedings will not move forward. Paragraph 1 of Article 17 of the law provides that the courts should effect service of writs of summons or such other litigation documents to a foreign state in accordance with the means specified in international treaties. However, there are only 82 contracting parties to a Hague Convention of 1965 Service Convention, and the bilateral judicial assistance treaty between China and other states is limited. And last, it is impossible to serve the defendant who is not a country party of the convention or bilateral treaty. So, the diplomatic service is needed. Paragraph 2 of Article 17 provides that where the service can be effected by means specified in the preceding paragraph, service may be effected by transmitting a diplomatic note to the diplomatic authorities of the foreign state, and the service should be deemed to have been effected on the date of the issuance of the diplomatic note. As mentioned above, diplomatic notes are handled by the Ministry of Foreign Affairs, and the certification issued by the Ministry of Foreign Affairs should be accepted by the courts. But other questions of fact concerning acts of state is also determined by the Ministry of Foreign Affairs. However, the accurate definition of this term is to be clarified. Then we turn to other Hong Kong and Macau's relations should follow the legislative immunity system according to subparagraph 9, Article 89 of the Constitution of China, and paragraph 1, Article 3, Article 13 of the Basic Law. China's Sovereign Immunity Act is binding on Hong Kong and Macau. According to Article 21, as Professor Dodge described, the principle of reciprocity. The principle of reciprocity is also related to countermeasures and a foreign policy tool. So maybe in some extreme cases, China will also use the principle of reciprocity to limit the state immunity enjoyed by other states. And Article 20 provides that provisions of this law shall not affect the privileges and immunities and the diplomatic law, including like international treaties and international custom. Therefore, when the Ministry of Foreign Affairs issued a written opinion providing that the defendant is diplomatic missions, then this opinion shall be accepted by the court. Then turn to paragraph 2 of Article 19, issues concerning major national interest. According to paragraph 3 of Article 19, the Ministry of Foreign Affairs has the right to intervene in court proceedings and may provide an opinion to the courts. For example, Article 3 to Article 12 of the law provides that the foreign states enjoy jurisdiction immunity and exceptions. Especially paragraph 2 of Article 7 provides the court shall consider factors relating to the nature and purpose of the act in determining whether an act is a commercial activity. So, if the Ministry of Foreign Affairs give an opinion on the purpose of the act, then okay. And there is also jurisdiction immunity exception that following the Ministry of Ministry
and the public goal.
Okay.
The Westlake.
MFA have other laws under the law. Then my conclusion is that following state immunity law allows the private parties participation into foreign affairs and divides powers between the Ministry of Foreign Affairs and the courts on the state immunity issues. And the Ministry of Foreign Affairs still plays an important role. And the individuals and organizations may also affect diplomatic relations through litigation. Thank you for your time and attention.